Welcome back to the courtroom where the excuses are wilder than the crimes. Today, we've got a defendant who thinks found fentanyl is a valid legal defense and another who treated a Texas highway like a Call of Duty map. You won't believe the stalling truck story coming up. Let's dive in.
Well, I mean, if he had a record of this, I would agree with that. But this is the first time that I'm aware of him out here doing such things.
This is the first time he got arrested for it. And he got arrested because they did an undercover sting, I guess, with him.
Right.
All right. So you're saying somebody just dropped fentanyl pills on the ground. That's your story. Okay. I honestly don't understand why I should give him probation because he's selling drugs. And then next thing you know, he's doing an evading arrest. I know people always come before me. They're saying he's young, he can change, but why does change always happen once you're in court? Is that not true? Is that not what happened?
Yes, Your Honor, that is why.
All right. If it's not what happened, just tell me. I'm here trying to figure out what the appropriate sentence is. There was bad behavior on both sides, but Mr. Giovanni, this is not a probation case.
Switching gears to case number 2, aggravated assault with a deadly weapon. In Texas, this is a second-degree felony. We're talking 2 to 20 years. The defense is trying to paint this as joking back and forth on the road, but the judge is already smelling a road rage disaster. Is it ever joking when guns are involved? Drop a NO in the comments.
You understand you're charged with aggravated assault with a deadly weapon. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you requesting a PSI?
We are, Judge.
All right. Is there a need for a TAP evaluation?
I don't think there's a need, but
All right. We'll do a TAP evaluation. Mr. Bustos, is there any mental health issues?
No, Your Honor.
All right. So, Ms. Ferguson, PSI and TAP evaluation. And probation, this will be PSI and TAP. And counsel, I'm sorry, I need the trial court certification back. Thank you. All right, Mark. Have both parties had a chance to review the PSI report
we have, Judge.
and the TAP evaluation?
We have
Any objections?
no objections, no corrections or addition.
Any objections from the state? No. All right, any witnesses, state?
No,
Defense
no.
witnesses?
Oh, yeah.
All right.
Yeah, only my client, just very briefly.
All right, could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yeah.
All right, you can lower your hand, state your name for the record.
Jason Giovanni Bustos.
All right, defense.
Jason, you admitted when you were here, you admitted to probation that you shot and gun at this other person, correct?
Yes.
And this had to do with on a road, you and another vehicle were playing jockey back and forth, correct?
Yes.
And I want to make sure the judge, the other vehicle was a F-150 Ford pickup.
Yes.
And you had a 95 Ford Ranger, correct?
Yes.
4-speed.
Yes.
And you felt threatened by, is that what you felt threatened by the actions of your driver?
Yes.
Listen to this logic. He felt threatened by a Ford F-150 while driving a 95 Ranger, so his first instinct was to open fire? He claims he overreacted because he's not very smart. Bold strategy. Let's see if the judge buys the "I was scared" defense when he didn't even try to call 911.
You know now, when you carry guns, things like this can happen. You can overreact. You understand that that's not very smart. Right?
Yes.
That's not a smart thing. You overreacted.
Yes.
Have you learned a lesson?
I did.
You think that you could be successful on probation?
Yes.
A lot of reporting, drug testing, fines to pay, community service, Have you seen gun safety classes? Think you can be successful in that?
Yes.
You have a drug problem?
I do not.
Pass the witness.
All right, any questions?
Mr. Bustos, so you stated that you were felt threatened by the other drivers, is that correct?
Yes.
But the encounter that you had with them, it wasn't a short encounter, right? It went on for several miles, correct?
Yes.
And so at any time during that period where you guys are going back and forth with each other, did you ever think to call 911 and to report that you were threatened by the behavior of this other individual?
I did not have a phone at the time. Person.
And so, I mean, there are multiple streets where you could turn off or just went into business and park. Did you do any of that?
No, there was heavy traffic during the whole entire incident.
Okay.
My first thought would be going towards the HEV that was right across from the highway, and I couldn't make it across due to just traffic flowing through.
Okay. And so there was heavy traffic in the area for testimony. So the way that you can reconcile this is to fire firearm twice. That was your reaction. Right.
Yes. That was after when I got away from several of from the heavy traffic.
Okay. So why didn't you choose to get away from the other vehicle?
I did try to get away from the vehicle.
But then you still followed them and shot.
I didn't follow them. I was being followed the whole entire time.
But in the stipulated evidence, it says that the other Ford was taking the turnaround, right, when you fired into the vehicle, correct?
No.
So we're talking about
When I took the turnaround, there was an HEV. The entrance to that HEV was very close to the turnaround. So instead of proceeding, I decided to go straight. When I went straight to the first light, I decided to go on a right-hand turn lane, and I noticed that the truck was still following me. Once I noticed that, and I checked my rearview mirror, he was already trying to try to jump over the curb to get to where I was headed towards, and I was trying to avoid just confrontation from him. So instead, I proceeded to go straight. When I got off the right hand turn lane, I went straight when the light turned green to the other light, and I didn't even make it halfway until I almost got into an accident just from trying to drive away. My truck stalled, and that's when I noticed the driver still proceeding and started tailgating, driving recklessly, maneuvering through cars through the traffic that I left behind. So from there, he caught up to me, and that's when I got scared and overreacted.
Okay. And so I want you to help me understand this, because in your interview that you gave with Detective Nash, it says that he stated that during some of the swerving that you catched up to the other Ford, and that's when the truck slowed down and tried to cut you off. And then
That was not.
that's when you exited and took the turnaround, and then that's when you shot into the other truck. So on the highway, you had an opportunity to catch up to him. Why didn't you just go somewhere else? Did you think that your response was reasonable to shoot into his vehicle?
No, it wasn't.
Let me follow up. I'm well familiar with the location. I live out there. When you exited at the Leon Springs exit,
Yes.
Bernie Stage Road. When you exited there to do the turnaround, it's up a ways and there's no place to turn off. It's a service road. It's very heavily trafficked. And you make the turnaround, there's an HEB on the right-hand side, but there's like 3 lanes there when you do the turnaround. You had to get over 2 or 3 lanes to be able to pull into HEB.
Yeah.
Correct. There's too much traffic. There always is like service rate. Correct. So you continue straight. Is that correct? And your truck is a Ford Ranger, a 4-cylinder.
Yes.
When they're talking about catching up with the individual, she brought up, did you accelerate to try to catch up?
Not accelerated.
What did you mean by trying to catch up? Or catching up?
What happened was, as we were driving forward
On 10.
on 10, he left it alone. I left it alone. I didn't do anything about it. There's no reason for me to catch up. I can't even catch up.
No, yeah, I understood.
Not against with the truck that has 8 cylinders against a Ford 4-cylinder truck. Anyway, I noticed from about a quarter mile, he was already tailgating another vehicle, but then again he starts to pull back dramatically.
Okay. What do you mean by you caught up with him? What do you mean?
I mean,
Were you trying to catch up with
I
him?
wasn't trying to.
The flow of traffic, you ended up getting ahead of him.
Yeah.
That's all I had. Thank you.
Any other questions? All right. So
Judge, I may just say this one thing,
yes.
if I may.
Here comes the judge with the facts. She lives in this area. Never lie to a judge who knows the local traffic patterns. She's breaking down the synopsis, which basically says the defendant was the aggressor, brake-checking the victim and brandishing his weapon twice. This wasn't a snap decision. This was a pursuit.
Hey,
Well, just 1 second, because I want something cleared up for me. In the report, I'm reading the synopsis, and this is what the synopsis says in the stipulations. It says that the complainant was in his personally owned vehicle. The suspect was in his vehicle, and the suspect began to brake check him on the interstate. I understand brake checking people because sometimes people are riding your bumper. I understand that. I think it's crazy to do that, but I understand why people brake check, say, hey, quit riding my bumper. So that's not the problem for the court, that you were brake checking him. It says that the complainant decided to pass you and continue on his way. So what the synopsis so far is saying is that you were brake checking him, I guess, because he was riding his bumper. And then the complainant decides, you know what, I'm just going to pass this guy. So it says that he passes you, then you caught up to him, pulled up next to him, didn't fire your weapon, but exhibited your weapon to him, and then got in front of the complainant and started brake checking him again. That's where I have a problem. I can understand you're driving. Maybe the speed limit is 60. Sometimes people will be in what's called the fast lane on the freeway, and they're going below the speed limit, which is a no-no. But let's say the speed limit is 60, you're going 50 or 55, who cares? You're going less than whatever. Or maybe this person is speeding behind you. So they're behind you, they're riding your bumper, which people do, which they shouldn't do, because that doesn't give you time to stop if you need to stop immediately. So this person says, you start brake checking them. So I'm sure tempers are high. His temper is high. I know the complainant was probably upset, probably said a few choice words. And then the complainant gets from behind you because you're brake checking him and speeds past you. Maybe he gestured towards you or whatever, but he doesn't pull a weapon. So he speeds past you. That should have been the end of it. Maybe you get on the phone. You say you didn't have your phone, but maybe you memorize his license plate and call the police and say this person is recklessly driving. But he says what happens is you don't do that. After you brake check him and he decides to pass you, you then catch up to him and exhibit your weapon. That's a no-no right there. And then it says, then the complainant, instead of him just calling the police after you pulled your weapon at him, he pulls out his phone to start videotaping you. And then what he does, after you pulled out your gun and exhibited at him, he starts filming you on his phone. And then he starts chasing after you in his vehicle to film you. And it says he continues to follow you. And then they both took the turnaround at Bernie Stage Road and went on the access road. And it says that the complainant then continued to record you. And then you both got off at the 20,000 block of Interstate Highway 10. And then you came to abrupt stopped as the complainant passed you on the left. And then when he passed you on the left, it says you started firing with your automatic handgun. And it says that the complainant was still filming on his cell phone when this occurred. So is somebody saying those are not the facts? Because that's what I'm reading.
The last part, Your Honor, from what I can remember, is he did not pass me up. He just stopped after I stopped.
Mhm.
I stopped just to make sure he can continue going.
So did you brandish your weapon more than once? Did you brandish your weapon at him first and then brandished it later throughout this incident and then shoot it?
I brandished it once,
And when you brandished it, you fired it.
only on the second time.
Okay, so then you brandished it more than one time. What the synopsis is saying, and don't feel that you have to agree with me. I'm just saying what's in the synopsis. What the synopsis is saying is you brake checked him. And then after you brake checked him, he went around you and past you. You brandished a weapon. You didn't fire it. He gets upset that you're brandishing a weapon. So then he starts following you and filming you. And then you all meet up and you fire bullets into his vehicle. So is that not true? Is that not what happened?
Yes, Your Honor, that is what.
All right. If it's not what happened, just tell me. I'm here trying to figure out what the appropriate sentence is. But I do have a problem if you're brandishing a weapon at somebody, right? And then later you brandished it again. There's a gap in time for tempers to cool. And then you brandished it again and you fire into a vehicle. Did you know how many people were in that vehicle? What if there were children in that vehicle? In their in their car seats, because you really can't see when babies are in car seats. People could have been killed. And then if you would have been a good shot and you would have killed him, maybe he would have crashed in other vehicles and somebody else would be dead. So you wanted to say something, counsel, or is there any other questions for him?
No, just something, an argument.
Sure.
Two things. One is 95 Ford Ranger. My wife, although she drives a new car, has a 96 Ford Ranger,
Mhm.
6-cylinder. She uses for hauling plants, shrubbery,
Mhm.
rocks, dirt.
Mhm.
Ford Ranger does not have a lot of pickup. Well, it has a limited speed it will go.
Mhm.
An F-150, it doesn't have a lot of acceleration. An F-150 has got a lot of acceleration.
Mhm.
So we've got a small car and a large car. I don't know what happened, but I'm saying there's a difference there. And the 150 ought not be picking on the smaller guy, if in fact that was what he was doing. Second off is his questions about why don't you call the police? I don't want my wife going down H10 and getting off on the service road going at 50 and 60 miles an hour, getting on a cell phone and making a phone call.
Oh, well, what I can tell you, counsel, the whole thing about calling the police, that's not the big issue for the court.
Oh, I know.
Yeah, okay.
And I think he understands what he made a mistake. Also, I think he's had some mental health issues. He took medicine. They got him back on medicines in the jail. He has no prior criminal record. He had a job. He was productive before this happened. There's nothing in the record that says this would be a reoccurring type thing that I can see. Once he's learned a lesson, give him a chance on probation. I'm asking the court to give him a chance on probation.
All right, state.
Maybe even have some mental health treatment if the court thinks that's needed.
Judge, we're talking that you denied the application. Prison. I don't know. What do you define? I think that it kind of, you can deny having a 30-year old, but the evidence that was stipulated to is problematic. That's his worst nightmare. To be fired upon while they're just driving down the highway. And my point about bringing up whether he called 911 or not was that he had a sufficient time to cool down or pull over and retreat, and he did not. He decided to engage and brandish his weapon one time and then fire it twice into that truck. And we love to do that. We didn't have that agreement because we would be here for a different charge if that were the case. And so for those reasons, we're asking.
All right. Is there any objection to the restitution of $250 to the complainant for his deductible?
No, Your Honor.
All right. The court is going to find you guilty. The court will sentence you to a $2,000 fine, time and money to run concurrent. There's an affirmative finding of deadly weapon. I'll ask for the therapeutic community based on the mental health. And I do understand, based from reading the synopsis, what was going on with both parties. And there was bad behavior on both sides. But
The hammer drops. Despite the defense's plea for probation and mental health considerations, the judge points out the cold truth: innocent children could have been in that car. 4 years in prison. No probation. Do you think 4 years is enough for firing a handgun into traffic? Let's hear your take below.
Mr. Giovanni, this is not a probation case. So what I'm going to do is I'm going to sentence you to 4 years in the prison, give you credit for any time served. There's an affirmative finding of deadly weapon. There's been no contact with the complainant, and $250 of restitution to the complainant. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
When we did all this, you don't have a right to do it.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. All right, we can go off the record. So I gave you something less than what the state requested because of the facts of your case. You're going to have to get a control of your anger, and you have to start making better decisions. A gun should not be the answer to every issue that comes up. All right, good luck to you.
And he gets credit for time served, right?
Yes.
So, yeah. It's a good thing to do. Because you'll be eligible for parole after 1 year. You get credit for the time you want to. So,
Thank you, counsel. That the state is proceeding on count 1, that's possession with intent to deliver a controlled substance, penalty group 1, 4 grams to 200 grams. That's a first-degree felony. Range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
In states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Probation, is there any way to expedite this, or is that too much expediting in the court?
It's only trying to be judged.
All right, Norma, could you put this, if we were to put this at the end of July, you think, just to see if we were able to do it?
Yes, sir.
All right, Norma, could you put this as for sentencing the last week of July? All right, we'll bring you back on July 29th. Counsel, of course, if it's not prepared, then we won't proceed. We'll get a new date.
Okay, thank you, Judge.
All right, thank you. All right, have both parties had a chance to review the PSI report, state?
yes.
Defense?
Yes, Judge.
Any objections, state?
No.
Defense?
No, Judge, just some clarifications that I'll clarify with witnesses.
All right, you may proceed. State is silent.
Thank you, Judge. Defense calls Katina McDaniel.
All right, Katina McDaniel,
Yes, ma'am.
do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do. Yes, ma'am.
All right, you can lower your hand if you'll state your name for the record.
Katina McDaniel.
All right,
Can you spell your name for the court reporter?
Yes, it's a C like Charles, Atina.
Thank you, Katina. May I call you Katina?
Yes, ma'am.
Thank you. And how do you know Clarence McDaniel?
He is my oldest son.
Okay. And can you tell the judge how many children you have?
I have 7,
Okay.
and he's number 2.
He's
I'm sorry, number 3.
Okay.
Yes,
But you did say he's your oldest
the
son.
oldest son. Yes,
Okay.
ma'am.
So it would be fair to say you have daughters that are older than him.
Yes, 2 daughters that are older than him.
Okay. And all of your children, you said 6, are they all living here in San Antonio?
Yes, they are.
At the time that Clarence picked up this offense, was he living with you?
No, he was not. Yeah, he had his own apartment.
Okay. Who was he living with, to your knowledge?
He was living with his girlfriend.
And Tell the judge about Clarence's childhood upbringing.
Clarence had a pretty normal upbringing all the way up until he was 12. That's when he lost his father. For maybe 1 to 2 years after that, we had a little trouble, but I think it was him acting out because of his father's demise. I don't think he ever really fully came to terms with that.
After his father passed away, did he have any male role models in his life?
Not really. And that's the thing, because a lot of people offered to step up and nobody really did after his dad died.
And what other family do you have living here in San Antonio?
My mom lives here, my dad lives here, and I have 2 sisters that live here.
Okay. And do you have family other places in Texas?
I don't, but he has family that's in Houston.
Okay. Clarence has family
Yes,
in Houston?
yes, he is.
Okay. Who are they?
His other grandmother lives there, and then he's got 2 uncles and 4 aunts that live out there.
Okay.
Mm-hmm.
And how old is Clarence?
Clarence will be 24 this year in December.
Okay. Has he had any adult criminal history, adult convictions that you know of?
No.
Tell the judge what kind of a person Clarence is.
Clarence, he's a lot like his dad. He's real shy. Doesn't talk a lot. Kind of keeps to himself, but I would say he has some of my personality too. He can be smart. I mean, if he applied himself, he could really go places.
Okay. And tell the judge about his girlfriend. What was going on when he got arrested in his life?
Well, the relationship between him and the girlfriend, I don't really feel like it was all that great. I think maybe I felt like he got caught up in this due to her demands. I don't know, but I just really feel like that. Because he was the only one in the house that was really doing anything. She wasn't working or anything. And then they had took on the extra responsibility of trying to raise her mom's kid.
Okay.
Yeah.
How old was
What do you mean? I'm sorry, trying to raise her mother's children? What do you mean?
Yeah, the daughter took the girlfriend's mother had a baby, and his girlfriend took responsibility of the baby.
Oh, so it's not his child and it's not the girlfriend's child?
Right.
Okay.
It would be fair to say it was the girlfriend's sister.
Right. Yeah. She was raising her sister pretty
Okay.
much. Yeah.
And how old was this child? Do you know?
She was young. She maybe was like, when they took possession of her, she was like 2 months, I think. Because I think CPS had stepped in and the girlfriend offered to take responsibility for the child.
So the girlfriend took placement from CPS.
Right.
Of an infant.
Right. Mm-hmm.
And do you feel that was a lot of pressure
I feel like it was.
on Clarence? Let me finish my question.
Yes, I'm sorry.
That's okay. Okay. And you understand we're asking the judge to give Clarence a chance at probation.
Yes.
If Clarence were to get out of jail, where would he live?
He could reside with me, my mother, his grandfather. He's got a choice of places to go.
And is there an opportunity possibly waiting for him in Houston?
Well, there is an aunt. I think she was one of the ones that submitted a letter that said that she owns a trucking company and she would be willing to give him a chance to come and drive for her company, the Tammy McDaniel.
Okay.
Mm-hmm.
And do you feel that being in custody, or I'm sorry, have you talked to Clarence while he's been in custody?
Oh, yeah. I talk to him all the time.
Okay. And do you feel that he has accepted responsibility for what he did?
Yes.
Do you feel that he is willing and motivated to do treatment or anything the judge asks of him on probation?
I really believe he will.
Are you able to be there and support him if need be through probation?
Oh, yeah.
And-
Definitely.
And anybody else in the family? Does he have any other people who will support
he's got support of both my sisters. He's got my brother-in-laws, his grandfather especially will definitely, yeah.
Okay. So he has a big support system.
A big support system, yes.
Is there anything else that you want to tell the judge?
I mean, he's young. He's made some mistakes.
Made some choices.
And I agree with that, yes. And I tell him that all the time. You're an adult. You know, I can't watch over you. You know, But I really feel that if he's given another opportunity, that he will get it correct this time, because he's made a lot of bad decisions, but I think he's finally coming to terms with those decisions. So, and he told me the last time he talks, he wants to work. He wants to get out, get him a job. He realizes that now the route that he chose was not the best route. So now he's more motivated to go out and work a regular job and make his, contribute to society the way that he should. I haven't had any contact with the ex-girlfriend, but I'm urging him or asking him, I think he should probably do this journey by himself.
All right, any questions? All right, so let's get to the crux of the situation. Here's the problem.
Finally, we meet Clarence. His mom is a nurse. He has a huge support system, yet he's caught in an undercover sting selling first-degree felony amounts of drugs. The judge asks the million-dollar question, why does change only happen once you're in court? It's a reality check for Clarence, and a reminder that a good background doesn't give you a pass on being a predator. Stay tuned for the final ruling.
He's out selling drugs.
Right.
And in the PSI report, he's saying you were not a good parent. His father wasn't a good parent. That his father went to prison, that you went to jail in 2017, and you all were always arguing and fighting in the house, and he got physical. So let's talk about that, because I'm trying to understand who he is and why is he here before me selling drugs.
Yeah, it did get physical between me and my late husband. I will admit to that. I don't feel like I was a bad parent. I did go to jail for a year. I came back out, got my nursing license, and went to work. So it wasn't like I was just, continuing this cycle. That was 8 years ago.
So I'm like, why is he selling drugs? That's what I'm trying to get to. And I'm trying to understand there is nothing then in his background that suggests that he should be selling drugs.
I agree.
And when people sell drugs, they ruin other people's lives. So why is he selling drugs? And it's not his girlfriend's fault that he's selling drugs. He's not 10
Right.
and she's giving him instructions. He decided to do this on his own. So the question is, why? Even though why is not an element of the offense, why? Because otherwise he should probably go to prison, because he's just being a predator on people who have addictions.
I don't really feel like he's a predator because he's never done this type of activity before.
Well,
I mean, if he had a record of this, I would agree with that. But this is the first time that I'm aware of him out here doing such things.
This is the first time he got arrested for it. And he got arrested because they did an undercover sting, I guess,
Right.
with him.
Right.
So he was setting up a buy. And he was doing it through text messaging.
Yeah. And when the attorney presented me with that, I had no idea that was going on.
So I honestly don't understand why I should give him probation, because he's selling drugs. And then next thing you know, he's doing an evading arrest. I know people always come before me. They're saying he's young, he can change. But why does change always happen once you're in court as opposed to doing something before? And in the PSI report, I don't know if you've read it. I've read it. It's saying that he would live 2 or 3 days at your house, then go live 2 or 3 days at his girlfriend's house.
I don't even know where the girlfriend lives.
No, what I'm saying is in the PSI report, he said that he would live 2 or 3 days at your house, then he would leave and stay 2 or 3 days at his girlfriend's house.
We stayed with the girlfriend longer than that.
We.
Huh?
When you say we, who is we?
No, I said he would stay.
Yeah, that's what he said. He'd say he'd stay there for a couple of days.
He would stay that longer than that.
Yeah.
Than 3 or 4 days.
Mm-hmm.
The only time he would come back to my house is whenever they were having disputes.
Mm-hmm.
And it really wasn't even that long.
Yeah.
So I don't know. It wasn't no 2 or 3 days. He was with her for a while.
No. I agree that it was over a length of time,
Mm-hmm.
but their relationship was one where he would stay at her house for a few days, then come and stay at yours, then go back and stay at hers for a few days. That's what I've read in the PSI report.
Okay. Well, I'm just acknowledging that is not what it was.
No, I understand.
Mm-hmm.
All right. Any other questions?
Not for this witness, Judge.
Thank you so much for coming in.
Thank you.
Yeah.
Defense calls Clarence McDaniel.
All right, you want to raise your right hand? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Clarence McDaniel,
Thank you, Judge. Clarence, tell the judge, how old are you?
23.
And I know the judge has already read the PSI, but tell the judge how your dad passing affected you.
Didn't really have a father figure, nobody to look up to when he passed. And I didn't really, I didn't have really a father figure once he left.
Was it hard on you?
Yes, ma'am.
And tell the judge about your girlfriend that you were with when you got arrested.
It was like any young relationship, it's kind of a little rocky, trying to have stability and take care of a kid, but I did the best I could do.
Okay. And tell the judge how you got custody of a 2-month-old baby.
We had to make sure we had an apartment and a car to somewhere for the baby to live, and then somewhere to get the baby back and forth to.
And Child Protective Services just decided this was a great idea. Okay.
That's my understanding, Judge. Is that what happened? Child Protective Services put the baby with your girlfriend?
Yes.
Okay. And who was all living together?
It was me, her, and the baby.
Okay. And how was that? Was it easy having an infant?
It was pretty stressful.
Were you working?
Yes, ma'am.
Where were you working?
I was doing tip agency job, really.
Okay. So not consistent, or was it consistent work?
It was sometimes consistent, yeah. I think.
I believe you told the pretrial officer this was the only time you had ever attempted at selling drugs. Is that correct?
Yes.
You had never sold drugs to anyone else before this day?
No, ma'am.
And what made you, that's the judge, you heard the judge, that's her question. Why? Why did you decide to sell drugs?
I was really just trying to support my habit, support my use. I just started using it, and I was just trying to support my use.
Okay. Were you also trying to get money for the baby, or just for your habit?
Not just for my habit, but I still, babies have needs too, so yeah.
Okay. Now, have you been in tell the judge your girlfriend's name.
Tasharia Harper.
Tasharia. Have you been in communication with Tasharia while you've been in custody? When was the last time you talked to her?
I believe last Sunday.
Okay, so still recently.
Yes.
Are you planning on still being with Tasharia when you get out of jail?
I'm not quite too sure. I don't know. Really, when you go to jail, you see kind of who's there for you and who's not. So I probably just try and work and get somewhere to stay by myself really quickly.
Okay, where are you planning on living when you get out of jail? If you get out of jail?
Grandma's house.
Your grandma's house. So where does she live?
She lives on the east side where my mom stays.
Here in San Antonio.
Yes.
Okay. And where do you want to look for a job?
I got an opportunity right now with the Buttercrust Corporation.
Okay, what would you be doing for Buttercrust?
Loading up trucks and unloading them.
Okay. And I know we've talked about the possibility of driving a truck for your aunt or uncle in Houston. Is that also a possibility you would consider?
Yes, ma'am. I just got to get my driver's license.
Okay. So you would have a job lined up either way?
Yes, ma'am.
Okay. Now, you've told the judge and the pretrial officer about your drug use. You've been in custody for a while. Are you motivated to stay clean?
Yes, ma'am.
Okay. You understand that if the judge were to give you probation, she could give you inpatient treatment, outpatient treatment. You'd have to drug test frequently, possibly go to AA or NA classes, all sorts of things. You understand that?
Yes, ma'am.
Are you willing to do all of those things?
Yes.
Have you ever been on probation before?
Yes, ma'am. One time.
For what kind of a case?
Possession of marijuana.
Misdemeanor case?
Yes, ma'am.
Have you ever been on any sort of felony probation? Do you have anything else you want to tell the judge?
I'm not a distributor. I don't distribute drugs. My first time ever trying to do that, and I was just trying to support my habit, trying to stay.
Sorry, one more question. I think the PSI says something about you think that they thought you could have made better choices. Who are you talking about when you said they?
The people that was affected by my actions.
Okay. What about you? Do you think you could have made better choices?
Yes, ma'am.
No further questions.
Judge.
And it stays silent, do they?
They're allowed to present questions if it's regarding facts.
Yes.
On the date of your arrest, you were by yourself, weren't you?
Yes, sir.
So your girlfriend wasn't involved with this.
No, sir.
And then you were in possession of 130 fentanyl pills.
No.
Well, the police reporter says that S1 advised me that he was trying to sell 130 fentanyl pills.
The one I seen said 100. What the indictment, what the police report I read said 100.
Nothing to say.
All right. So I'm assuming in your thought process, you had to get pills from somewhere to be able to sell them, or did you make them in a lab?
Make drugs.
So you had to get them from somewhere.
Stopping and I was walking to the store.
Oh, you're saying you just found them on the ground?
Yes, ma'am. Like somebody dropped them and I found them.
No. Then how did you know they were fentanyl?
Searched up what was on them on my phone, and they didn't come back with fentanyl pills.
All right. So you're saying somebody just dropped fentanyl pills on the ground. That's your story.
Yes, ma'am.
Okay. All right. Anything else?
Just argument, Judge.
All right. Court will hear argument.
Judge, Mr. McDaniel is 23 years old. He has very limited criminal history. I understand this is a very serious offense. However, he is highly motivated to do anything and everything on probation if given the opportunity. And this isn't a case of a hardened drug dealer, of a person who, has been selling for years and years. This is a new user, a new dealer. Unfortunately, the first time he sells to an undercover cop, and he deserves a chance to show that he can change. He deserves a chance at rehabilitation. He deserves a chance to turn his life around. And that's all we're asking for.
All right. The court is going to find you guilty. Court will sentence you to 5 years in the prison. Give you credit for any time served. This will run concurrent with County Court 14, cause number 726688. Take in consideration County Court cause number 726689, 726690, 2024 CR 4841. And the complainant is saying that she wants her deductible for the vehicle that he hit.
Yes.
And that is in
$500.
Yes, $500. And let me see which cause number that is in. All right. There's to be restitution of $500 to Roxanne Pereira and cause number 726689. With regards to Escalante Javier, the court does not have any restitution in the PSI report, so the court is not ordering restitution in that. Court will note that this PSI has been pending since July, so person would have had time to give a proposed restitution amount. All right. And I'll order the therapeutic community. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question of what a weapon or ammunition is, you'll need to speak to your attorney, and I'll retain jurisdiction.
Thank you, Judge.
You're welcome. Monica Guerrero, are you ready on your case?
We have one case on the docket today, State versus Sarah Jo Fuson. And we are ready to proceed with the sentencing hearing. The state may call your first witness.
We'd ask that Your Honor incorporate the proof from the trial into this hearing today. and we would call Miss Macy Hyde. And have you prepared a victim impact statement today that you'd like to read?
Yes, sir.
With your court's permission, I would ask her to read.
Boy,
Your Honor, my name is Macy Hyde, and I am the mother of the child who has been deeply harmed in this case. There are no words to describe what it feels like to realize your baby has been harmed by the very person you trusted to care for her. I had trusted Sarah with the most precious thing in my life, my daughter, and that trust was shattered. I am here today to share the profound and lasting impact the defendant's actions have had on my daughter, on our family, and on me as her mother. Though too young to fully understand what has happened, continues to suffer the effects. For months after the incident, she woke up screaming in the night. She had panic attacks and was showing an overwhelming fear of sleep. Putting her down at naps and bedtime became an emotionally charged ordeal. As a mother, the emotional turmoil has been unbearable. Every day, I live with the constant anxiety that my children may be hurt again, fear that grips me every time I drop them off at school or leave them with anybody other than myself. Things that once felt routine, like school drop-offs, babysitters, and playdates, are now moments of intense dread and second-guessing. I regret deeply back to Sarah the day after the abuse. The guilt that haunts me for that decision weighs heavily on my heart, and I still to this day struggle to forgive myself. After watching the trial videos, my husband and I experienced nightmares, uncontrollable tears, and unable to shake the images from our minds. We both sought therapy to cope with the trauma, including EMDR, to help erase the haunting memories. Rewatching the footage in October just reopened old wounds, bringing back intense pain and the memories of that time. Our daily life has been irrevocably changed. My children have become more cautious, and I have become hypervigilant. Every change in behavior raises a red flag in my mind. The fear I now carry is not a life that I ever imagined for my children. Yet it is our new reality. The trust we once had in the world around us is shattered. Sending my children to school or leaving them in the care of others now feels like a risk that I cannot fully bear. The ripple effects of this trauma has permeated every part of our lives. I ask the court to fully understand the deep, lasting harm that this has caused. I thank you for allowing me the opportunity to share the impact this trauma has had on our lives. And I hope the court's decision reflects the gravity of the suffering and the fear that my family continues to endure. Thank you.
And you are the mother of Sarah Fuson, is that right?
Sarah's mom, yes.
And where do you live?
Lived there my entire life.
And how are you employed?
I'm a school teacher, elementary school teacher.
How long have you been a school teacher?
And this is year 28.
Describe your relationship with your daughter, Sarah.
When Sarah was born, she was the biggest gift in our life. We just enjoyed, she was the sweetest child. She gained the nickname Sweet Sarah. Everything about raising her was a joy to me. We were actively involved in our church, and one of the greatest blessings was she was baptized at age 7, and that gives me lots of comfort.
If you would describe for the judge the impact that this prosecution and trial has had on Sarah.
From the beginning, there was an immense amount of media and social media coverage because of who her father is. This caused extreme embarrassment and shame. I knew that day, January the 10th, when I came home from work and heard what Sarah's account, that very confident, independent girl that we knew and raised was gone. As time went on, she felt that life had no meaning and like she had a gorilla on her back. We committed her to a mental hospital for a couple of weeks. She came home on lots of mind-altering medications. The medications would change off and on. In the process, she's gained about 50 pounds. Got her kind of back a little bit mentally stable. Trying to get a new job was very embarrassing, to say the least. She would attempt one after another. with the charges on her record, it would come back when they did a background check. So she would get fired. And some of those firings were very, very humiliating. During this period, I made sure Sarah was with me or someone at all times. I did not feel safe leaving her by herself. Everything is worrisome and extremely painful. I am so sorry for all of your pain and all of the trauma and all of the mistrust in society that this has caused you. I've tried. I wanted to from the very beginning to reach out. I was advised not to. I even wrote you all a letter. And I know it wasn't given to you. We do not, as a family, condone what Sarah did that day. We don't, but we do love our daughter. Also know that Sarah did not think her actions at the time were hurtful. It was only when she saw herself on video that she thought, yeah, that was rough. Sarah was raised in a home of public servants. She only wanted to serve others. Sarah is not a throwaway person. She is kind. She is generous. She is loving. As her family, we need her. We depend on her. And we will have a big hole at our table and in our hearts until she is returned home to us.
Thank you. Those are my questions. Go forward with your statement.
I want to start by apologizing to Ms. James, the probation officer, about my comments about the case. I was still adjusting to jail and was going through a difficult time. That's not how I feel about the case. I had been working at Tylertown for 6 months when this happened. I loved my job, I loved the children, and I got along very well with the staff. I used to look forward to going to work every day, to be with those children and be in the environment. I was always alone with 6 children in my classroom. Sometimes it was difficult to give one child the attention they needed when I had 5 others to care for. I find myself hurrying and multitasking all the time. It was also hard to give the new children the attention they needed to transition into the toddler room. I didn't realize I was being rough with in the moment. I recognized that I was rough with her and regret my conduct. If I could go back and make this right, I would have been calm and gentle as usually I was and not rough. I love children and animals, and it is not in my nature to be rough. I want to thank my parents and my family for supporting me and standing by me through this very difficult process.
Thank you.
That's the sentencing spread is 15 to 25 years. Under recent amendments to the law that apply in this case, it is 100%. There's no parole. There are no credits. Serve every day. My position is pretty simple. The government's pleadings say they want a sentence more than 15 years. They haven't said what number they want, but they want it more. I think that a sentence of more than 15 years is brutal, unnecessary, and inconsistent with the sentencing law. I want to think about 15 years for a minute. I think everybody on this side of the table went to college, most of us. That's 4 years. 15-year sentence is 4 times of being in college. When you put it in real terms of spending time, it's forever. The college was an education, and for most of it, it was having a good time. Being in prison for 15 years is being locked up in a cage. I was at the penitentiary at the women's prison 4 days ago for Old Henry. There's barbed wire everywhere, silent as a tomb. You don't throw sentences around like candy anymore. There's no such thing as a mid-range sentence to make everybody happy at one end or happy at the other end. We are talking about real years here. But now the sentences are at 100%. The sentencing mindset that we had 5 years ago is inapplicable today. Our sentences have gotten inflated, but there's no change in the sentencing lengths. It doesn't work the other way, unfortunately, when the sentences are at 100%. So we don't have to talk about the fantasy that we engaged in where you say, well, you give somebody 9 years and maybe they'll be out in 3 and maybe they won't. So maybe we can adjust the sentence accordingly. This is real time. It's just like the federal government. When Mr. Strines and I go to federal court, it's 100% over there too. But the federal government had some common sense. You can believe that. They reduced the sentence lengths to account for doing away with parole. And we engaged in utter madness in our state, where we left the grids the way they were and went up there. This is not the time or place for me to complain about that. We'll pay the price for that one day. And there'll have to be another sentencing commission to undo all this mischief. But the problem is, Your Honor is imposing a sentence today that's 100%. That will not change. We incarcerate more women in this country than any other country in the world, with the exception of some Middle Eastern countries that actually kill women. The sentence says under 102 must be imposed that is justly deserved in relationship to the seriousness of the offense. Justly deserved. Why in the world does this girl need more than 15 years at 100%? The law also requires elimination of unjustified. Punishment must consider restraining defendants with a lengthy history of criminal conduct. That we're not have that. Ms. Fuson does not have any prior history. Next, the court has to consider whether other measures less restrictive than confinement have been applied unsuccessfully. She'd been on probation 5 times. Violated them, of course the court would consider that. So we've tried everything we can. Your Honor does that every day. That's not what we have here. And most importantly, the sentencing principle says the sentence imposed should be no greater than that deserved for the offense committed. That's the so-called parsimony provision, the least possible sanction. No greater than that deserved. We have to balance everything. Why in the world should this woman deserve more than 15 years in hard labor in prison? In 15 years, Your Honor, nobody's going to care or know.
Are we now having inmates perform hard labor like chain gangs in the prison system?
No, they
that I'm
don't.
unaware
But that's
of?
what the statute seemed. The statute said you got to give them a Bible. That they're supposed, they have these archaic.
I just didn't know when you mentioned 15 years at hard labor that was actually an accurate representation of our prison system.
Well,
I understand it's an eloquent reference to other images that we create by putting people in prison, but go ahead, I'm sorry.
Your Honor, I don't want to go too far afield, but I have had constant calls of prisoners being subject to abuse and killed in prison.
I understand that prison is not a pleasant experience.
It's without using profanity in the court, it's heck on earth. It's a terrible place. It may not be hard labor per se, but it's a hard life. People are extorted like crazy over there. If she said, I did not knowingly intend to harm this child, that's true. But she did nevertheless. But she was acting in a reckless way because the statute said should have known. And should she have known that she was harming this child? I suppose so. But I suggest this is much different than the child abuse cases that Your Honor sees, where the child is being shaken all right to the point of death. And they know what's happening, and they intend to harm the child that she didn't intend to harm. I suggest that should be weighed in the balance as well. It doesn't diminish the pain that the parents feel, but it's not the intentional crime. Now, let's talk about 4035-210. Says that the minimum sentence within the range of punishment is the sentence that should be imposed because the General Assembly set the minimum sentence for each felony class to reflect the relative seriousness of each criminal offense of classification. That's what it says. That this is not that complicated. That's what the statute says. It's the minimum sentence. That's what the legislature said. Its risk assessment is low. That is a factor the court's required to consider by, is she a threat? No, she'll never work in a daycare center ever again in her life. She'll never be near children in the rest of her life. Impossible. Her risk is low. Is that a mitigating factor? Of course. If it was high, the state would be up here saying and waving it around. They're not. 15 years will deter any human. For all those reasons, I'd ask, this person here is a human being. These laws were designed to reflect a sentence for her. The indictment is the state of Tennessee versus her. And the court is the arbiter of what that sentence should be. That's why we have judges. Sentencing guidelines are advisory. But at the end of the day, it's a very human experience. 15 years at 100%. I never thought I would stand in a courtroom in this state and say that. That's what we are today. No sentence more than 15 years. And would be inconsistent with the guidelines. And I thank you, Your Honor.
With all due respect to counsel, I've been around for a long time, and I've heard this before, and perhaps it should be addressed to the legislature, but that's not where we are here today. Your Honor, presided over this trial, heard all of the evidence, read the pre-sentence report, considered the statements and testimony here today, and on behalf of the state of Tennessee, I would submit that, yes, at this point in our history, the legislature, for some crimes, has decided that, yes, a person must do real time for a real crime. And this was a real crime. State certainly submits that whatever sentence Your Honor imposes will be based upon the law, the evidence, consideration of all the factors. But on behalf of the state of Tennessee, Olivia Hyde, family of the state, does sincerely believe this should be more than the minimum sentence. Thank you.
Well, any court that has to impose a sentence in a case like this is required to follow, as has been pointed out by both sides, the considerations and the guidelines that our state legislature has put in place to govern the sentencing in criminal cases. Those sentencing considerations are set forth in Tennessee Code Annotated 4035-103. And that provision states the following: to implement the purposes of this chapter, the following principles apply. Sentences involving confinement should be based on the following considerations. Confinement is necessary to protect society by restraining a defendant who has a long history of criminal conduct. Confinement is necessary to avoid depreciating the seriousness of the offense, or confinement is particularly suited to provide an effective deterrent to others likely to commit similar offenses. Or measures less restrictive than confinement have frequently or recently been applied unsuccessfully to the defendant. Obviously, this, as has been pointed out, is a case that requires whatever sentence I impose, the minimum sentence is 15 years, and the service is 100%, meaning she's not eligible for parole at any point in time. So some of those considerations are not really relevant. Obviously, the only one this court would be inclined to consider of those factors would be that, it is in this court's opinion important not to depreciate the seriousness of the offense. This court observed this trial. I observed the defendant's behavior during the course of the trial and her testimony from the stand during the trial. I'm not sure that I have, before today, I didn't see any indication that Ms. Fuson accepted any responsibility for this. In fact, to the contrary, she not only didn't accept responsibility for her actions, she minimized those actions. She gave excuses for those actions. She talked about how badly she was being mistreated and how unfair things were. I think it's instructive, even though this has been made an exhibit, that when the pre-sentence report was prepared, it's an opportunity for a defendant to give their version of the events. And when our probation officer went to, Ms. James went and talked to her and took her pre-sentence report and gave her an opportunity to be heard, here's what she said. It was O's first day in my classroom, and I was having issues with her sitting up in her chair at breakfast time. So I quickly yanked her back in her chair to keep her from falling to the floor. The second video is of nap time, and I was trying to get her to lay down. She wouldn't, so you can see me laying her down several times, and some parts did look rough. They say I caused bruises, but also say I caused a head fracture. I made sure she did not hit her head, and it was medically proven that she didn't have a skull fracture. But here I am in jail for it when it's not what that was. It was a wormian bone. Then during the interview on November the 13th of 2025, the defendant reported that she was not frustrated during the incident and was only trying to keep the child from falling out of her chair during feeding and trying to get the child to take a nap during nap time. On multiple occasions, the defendant made the statement, and I'm going to quote it exactly as it's written. I shouldn't effing be here. I didn't do anything. She also stated she had talked to friends, and plenty of them say they had handled their own kids that way. She stated that the victim's mother is a liar, and that the child was fine the next day, and that she brought her to the daycare and handed her to the defendant. She reported they lied in court and the child had no fracture on her skull. She stated the bruising on the child's arm just looked like a rash, and that the defendant's family is, quote, pissed because she shouldn't be there and she didn't do anything. She reported she wasn't allowed visits at the jail and that her family needs to sue the jail so she can get out of there. She also discussed how the food sucked and she really wanted a Dr. Pepper. The interview became solely focused on how this incident has affected the defendant with no concern for the child. That is the pre-sentence version of the events that Ms. Fuson gave. Now today, we saw a different side of her, and obviously if anyone who has a good lawyer is going to tell the defendant that you've got to come forward and make an allegation where you show remorse, I just don't find in this court's opinion that her expressions of remorse today are particularly sincere. I think they're motivated by good advice of counsel, as well as the fact that she realizes, having said those things, that those things can come back to bite her. Based upon all of the factors that the court has considered, my observations of the trial, the demeanor of the defendant, both at trial and during her testimony, her statements in the pre-sentence report, and all of the other factors in this court, I'm of the opinion that as to count one of this indictment, the defendant should be sentenced to 20 years in the Tennessee Department of Corrections. In count two, I found that she should be sentenced to 4 years in the Tennessee Department of Corrections, and those sentences will run concurrently with one another. And that is the judgment of the court. As to the motion for new trial, I know that there's already been a motion for new trial that has been submitted. However, the court is of the opinion that the state needs an opportunity to respond to that motion or to prepare for that motion. I'm here in January, and we can set it for argument on January the...
Also, I'd ask, Your Honor, when the court adjourns, if my client can be put in the back, Mr. Striance and I need to confer with her.
That's fine. There's a room that we can allow that to take place.
Thank you.
All right, this court stands adjourned.